Registry Matters is an independent production. The opinions and ideas here are that of the host and do not reflect the opinions of any other organization. If you have problems with these thoughts, FYP.
Recording live from FYP Studios East and West and Double West, transmitting across the internet. This is episode 334 of Registry Matters. Larry, you had forgotten to change the 334 there at the top, but I fixed it for you. How are you tonight?
Doing awesome. Glad to be back after a little vacation.
Yeah, I went and saw the symphony last week. It was great. Chance, you're joining us again. How are you?
I'm doing good. Very busy, writing a book, doing some photography. Yeah.
Everything with black and white, of course, right?
Everything with black and white.
Do you do anything else? Do you do anything else with filters, or is it just straight black and white out of the camera?
It's just straight black and white out of the camera. That's it.
You don't push any of the blues or the reds in the black and white settings?
No, because I shoot with a monochrome camera, and so so I do some post-production stuff, but
you shoot with
that's
film?
Just minor.
You're shooting with film?
Digital, believe it or not.
Oh, okay. I was just checking.
Yeah.
Wow. Larry, tell me what we're doing tonight.
Well, it's Mr. Gloom and Doom, but we're balanced by having Chance, as you've already introduced him. So he's going to offset my gloominess. He has a California corner segment. We have a case from the state of Wisconsin dealing with lifetime GPS monitoring. And we also have a case from Illinois where a PFR challenged a soliciting ordinance. And we have an article about some recent changes made by the Florida Supreme Court dealing with a speedy trial. And I think you've got a question from one of our longtime patrons here that I'm going to try to botch up as best I can.
I imagine that you will. And I spoke to Chance a little bit beforehand as well. And Chance, if you want to chime in, feel free. Big Mike, he's in a college class and they're doing some constitutional stuff and it's about the Bill of Rights. And it seems that to him that they were intending for the Bill of Rights, that they were intending to protect individual rights rather than group rights. I back up a step. I had to change this question around because it needed to be expanded and made more coherent out of it. But if the Bill of Rights were meant for groups, they'd have been written that way, wouldn't they have?
Well, if you're a textualist, yes, you would believe that.
And so what do you think that the original intent was? Was that to guarantee personal freedoms for each individual?
That's what I think the original intent was. That was a few decades before I was born. But not long, but the founders crafted the Bill of Rights with the idea that every person holds these rights, not just members of certain groups.
All right. Well, that part makes sense to me. So, but this, I've considered the Ninth Amendment. I sort of kind of memorized them at one point, but the Ninth Amendment seems kind of vague. But it has been used in the past to support rights like privacy and travel, even though they aren't explicitly listed in the Constitution. How does that work if something's not explicitly listed that you have that right to do that thing?
Well, if I actually knew the Ninth Amendment, but I ask AI since I don't know. And AI knows everything, right?
It knows many things.
Well, the Ninth Amendment essentially says that the enumeration of certain rights shouldn't be taken to deny other rights retained by the people. Now, that's about as clear as mud. This has led to arguments that unenumerated rights, like personal right to privacy or freedom to travel, are protected even though they're not actually spelled out.
Is that also kind of like where, I can't remember her name, she said that you have a right to parent your child? Is that an unenumerated right?
I would think so, yes.
Ashley, that was her name. All right, well then here's a question that got Mike thinking. Has the PFR registry ever been used to challenge on Ninth Amendment grounds? I mean, being on the registry affects privacy for everyone that's listed and can even restrict travel to some degree. Isn't there a valid angle for a legal challenge?
That's a really good question. See, Mike is brilliant. Legally speaking,
I agree.
Most challenges to the registry haven't focused on the Ninth Amendment, at least to my recollection. And courts typically uphold these registries by emphasizing the state's compelling interest in public safety. And the registries are always seen as necessary, even if they impose some limitations on individual privacy and their movement of individuals.
And I guess you could probably make a better argument that if someone is still on some kind of supervision, parole, probation, whatever they call it in their particular area, that the restrictions seem more justified. But what about after they've completed all of their sentence, their custodial requirements? Shouldn't they have the right under the Ninth Amendment to be left the F alone?
Well, in theory, and that's been what I've been reading into the Smith versus Doe, because it says one of the core principles of the Kennedy-Mendoza factors is disability restraints. But once someone has served their complete sentence, you could argue that continuing to impose any restrictions infringes on their unenumerated rights to privacy and free movement. However, the prevailing legal view has been that the ongoing registry serves a public safety function that outweighs those individual concerns. Apparently, it's a tough balance to strike.
And that sounds like it's an interesting tug of war between protecting individual rights and ensuring community safety, which we could probably put that in a lot of scare quotes, because does it actually protect much public safety? But while the Ninth Amendment challenge is an intriguing idea, it's still largely untested and hasn't gained much traction. I've never heard of a court case, and I don't think Chance has either. Have you ever heard of anybody challenging this on Ninth Amendment grounds?
Was that for Chance or me?
Well, for you.
Okay, I have not, and the courts are not permitted to invent challenges that you have not asserted, but I have not heard of that being asserted. But let me just clarify that even on the challenges that we make, we refuse to bring in evidence to support that. We just come in with hypotheticals that there's a disability or restraint, but we don't come in with solid evidence showing the true extent of the disability and what it's restraining a person from doing. But it's an innovative argument, but there's not been a landmark case that successfully uses the Ninth Amendment to overturn any aspects of the registry for those who've completed their custodial obligations. And courts are going to be very cautious about this unless solid evidence is put before them, and solid evidence has been lacking.
God, that almost sounded like a segue into something else.
It very well could be.
Well, all right, Chance, what were your thoughts there?
Well, as we spoke about before the program, and as Larry said, the registries are usually seen as necessary, even if they impose some limitations on individual privacy and movement. And that really is where the rubber meets the road. And that's where you get the analysis, which is, whether the ongoing registry serves a public safety function that outweighs those individual concerns. And so that's the balance that's always stricken. Well, you could argue Ninth Amendment, but it's going to really come down to that. That's where I think it's going to be. And so even if you're off supervision, you still are on the registry. So you're being supervised in the community anyway, because registration is just supervision. Okay. It doesn't have the same constraints as probation or parole. It's the same thing. And the same analysis has been applied to it.
Interesting.
I want to push back on that. I don't think that the registration should be viewed as supervision. It is, but I think that we should build a case contrary to that. We should come in with evidence of what registration are. Like, for example, young men between 18 and 26 have to register for the draft. We don't supervise them in any way. We only lock them up if they don't comply, and we deny them student financial aid and a plethora of government benefits. But they are free to move about the country or around the globe or do anything they want to do, as long as they stay in touch with selective service. And I think that we need to make it clear that this is a civil regulatory scheme that involves no law enforcement, no monitoring, simply keeping your file up to date. But we don't do that.
No, we don't do that, and we're dealing with what the public perceives as a boogeyman. So this is where we're at, and this is why we get that kind of analysis.
Well, moving along then over here to this long-running case from Wisconsin, and it is Alton Antrim, and that's individually and on behalf of others similarly situated, versus Jared Hoy, in his official capacity as Secretary of the Wisconsin Department of Corrections, and on behalf of all others. Does this mean it's a class action suit, Larry?
It does.
So it's a challenge concerning lifetime GPS monitoring. How did it go for the PFRs?
It didn't go very well, to be polite.
Well, do you mind if I set it up a bit to give some backstory?
Yes, go ahead.
All right. According to the court, after nearly 6 years of litigation, this class action lawsuit has been whittled down to a single Fourth Amendment claim challenging Wisconsin's lifetime GPS monitoring of certain repeat offenders. How was the case resolved? And I'm assuming there was a trial?
No, not exactly. Both parties moved for summary judgment, offering competing research on the recidivism rates and the efficacy of Wisconsin's statutory monitoring scheme.
So say that again. There was no trial?
Isn't that mind-boggling? A case that goes on for 6 years and there's no trial. I know you'd be befuddled, but no, there was no trial. The case was decided without a trial.
I'm confused. The court noted, while the social science might be relevant to policymakers deciding whether to enact such a scheme, it does not alter binding Seventh Circuit precedents confirming the reasonableness of Wisconsin's GPS monitoring program in a very similar context. Was this case wise from the beginning, in your opinion?
It's hard to answer that because I'm not on the inside very much on this case. And I'm generally in support of litigation that has been thought through very carefully, even where there is adverse precedent. My big complaint is when you are litigating where existing precedent does not support you, it's especially important to distinguish your case from that binding precedent. The court noted, quote, under the precedent which plaintiff Alton Antrim failed to distinguish, the statute is constitutional as applied to him. Did they just hope that prayer alone would overcome binding precedent?
Now, you have pontificated for years about the importance of plaintiff selection. Was Antrim a good plaintiff?
Well, I'm tempted to play the laugh track again, but I won't. Antrim was a 67-year-old widower and a lifetime registrant and diagnosed, quote, pedophile, according to the court. Antrim was twice convicted of first-degree sexual assault of a child, first in January 1991 and again in April 1999. He admits to victimizing a total of 8 victims, all between 5 and 10 years of age. In October of 2018, Antrim was discharged from extended supervision and is no longer under any form of criminal supervision. Does that sound like a person who would be viewed as a sympathetic plaintiff to you?
No, not at all.
Well, I contrast that to a case in Georgia. You remember the school bus stop case?
That's just before my time.
Oh, yeah. Well, and her name's escaping me. I'm having a senior moment. But she was over near Augusta, and the Columbia County Sheriff decided he was going to teach her a lesson about the law. And her horrible sex offense was that she was 17 and she had given oral sex to a 15-year-old, I believe it was, when they were both high school students. And she was at that time married with her own children. Now that's a sympathetic plaintiff.
Right.
Well, let me set this up a little bit if you don't mind. The Wisconsin statute 301.48 requires the Department of Corrections to maintain lifetime GPS tracking of people who have committed serious sex offenses, including offenses against children. Individuals subject to this must wear an ankle monitor at all times. Now, you ain't really wearing it. It's strapped on you permanently.
I know, right? And you can't take it off.
So I don't know
it's
why
attached to you.
That terminology. But according to the court, the monitor is unobtrusive and fits under the clothing. Now remember, if you had a little bit of evidence in the record, you could have shown what the damn thing actually does and how it works. The DOC does not track subject individuals in real-time basis, but instead analyzes their location every 24 hours to check whether the offender was present or near school, playground, or other places that might arouse suspicion. So what they're saying is that this is not real-time; it's delayed. It's a download or upload to the cloud. Tracking is terminated if a subject moves out of the state.
Is there any mechanism to have the monitoring discontinued?
Yes, an individual can petition to terminate tracking after 20 years, and that's subject to an approval, and that's under Section 301.48, subsection 6.
Now, I want to walk through the progression of this case, if you don't mind. So
Sure,
on March,
sure, that
okay,
that saves me some work.
So on March 18th of 2019, 8 named plaintiffs filed a lawsuit challenging the constitutionality of Wisconsin Statute 301.48 under the 4th and 14th Amendments. Those plaintiffs also moved for a preliminary injunction. They amended both of their complaint and preliminary injunction motion the next day. So then on May 1st, just a couple months later, defendant moved to dismiss counts 2 through, 4?
4.
Of the amended complaint. On December 17th of 2019, after briefing was completed, Judge Pamela Pepper, to whom the case was then assigned, held a hearing to address both motions. At the hearing, the court granted defendant's motion to dismiss and denied plaintiff's request for a preliminary injunctive relief.
You are correct. And as a result of that ruling, only count 1, a Fourth Amendment claim, remained to be litigated.
The plaintiffs immediately appealed the denial of their preliminary injunction motion, and then on September 23rd, 2020, while the appeal was pending, the case was subject to a judicial reassignment. Almost 2 years later, on June 21st, 2022, the Seventh Circuit affirmed the denial of plaintiffs' request for preliminary injunctive relief, concluding that plaintiffs could not show a likelihood of success on the merits of their Fourth Amendment claim. The Court of Appeals explained the plaintiff's claim was largely indistinguishable from Bellow versus Wall, and that's 811 Federal 3rd 929, which upheld a challenge to Wisconsin's statute of 301.48 as it applied to PFRs released from post-prison civil commitment. Brom, 37 Federal 4th at 1274 through 75. Based on Bellow, the Seventh Circuit agreed that plaintiffs were unlikely to succeed on the merits of their claim and returned the case to the court for further proceedings. Now, was that not a warning shot that the case was in trouble?
Well, it would have been to me, because the whole essence of the standard for it's basically a 2-pronged test. There's a couple more prongs that are not as relevant, but you have to show that the existing case law provides you a vehicle that you're likely to succeed on the merits, and that your claims are so similar to the existing case law that once the case goes to trial, that you're going to prevail, and you have to show the second prong, that there'd be irreparable harm. But it would have been a warning shot to me, because I've already got a telegraph machine to me saying, you ain't going to succeed on the merits because case law is against you. So I'm going to say, let's see. They've just fired a warning shot at me saying I'm not going to succeed, and they've denied my injunction. What can I do to enhance my case and distinguish myself from existing precedent? Now that's, I don't know if they teach that in law school. We do have an attorney here, but that's what I would have inferred from that. Chance, am I missing something here?
No, I don't think you are. I mean, if there's prior precedent, you might want to distinguish yourself, and that they do teach in law school.
Okay, they do teach that. Okay.
Yeah.
The court stated to survive summary judgment, he, which is Antrim, must explain why the GPS monitoring regime is an unreasonable search as applied to him and distinguish his claim from the plaintiff in Below and as interpreted in Brom. Because Antrim has not overcome these hurdles, his claim fails as a matter of law. I thought the U.S. Supreme Court has weighed against GPS monitoring for life.
They did, to a degree, and that was in Grady versus North Carolina in 2015. The Supreme Court confirmed that GPS monitoring of PFRs constitutes a search under the Fourth Amendment. But in so holding, the court, however, recognized that a GPS monitoring program for PFRs could still pass constitutional muster if it's reasonable. Now remember, I've pontificated also for years that you can do almost anything if you do it with narrow tailoring. And that's what the Supreme Court said. You can do this, but you've got to be careful. You can't just arbitrarily apply it to everyone indiscriminately. And that's what Grady stood for in 2015.
So how does one determine if the search is then reasonable?
Well, I wish they used my standard, but whether the search is reasonable, my standard would be that there would have to be an individual articulatable set of facts, kind of like when you apply for a search warrant. There has to be, Chance has probably reviewed dozens, if not hundreds of these in his career, and there has to be an affidavit sworn by a peace officer that here are the individualized articulation of a set of facts that would justify us intruding into this person's life to search their personal space. But whether search is reasonable, according to the courts in this instance, it's the totality of the circumstances, including the nature and purpose of the search and the extent of the search, which intrudes upon reasonable privacy expectations.
Now, the court noted that in below, the Seventh Circuit applied this test to Wisconsin Statute 301.48, a subsection of the Wisconsin's lifetime GPS monitoring statute that applies to PFRs released from post-prison civil commitment. In that case, the plaintiff was twice convicted of assaulting a child. After 5 years of civil commitment, he was released from all supervision on the basis of the opinion of a psychologist that he was no longer more than likely than not to commit further PFR-type offenses. He then learned that he would nevertheless continue to be subject to lifetime 24-hour GPS monitoring under subsection 301.48 2B2.
So, and on that name, I'm thinking it's Ballou, the Belleau, but I'm not sure either. I think that might be Ballou. But anyway, he responded by suing the Wisconsin Department of Corrections in federal court, claiming that the statutory monitoring scheme violated his Fourth Amendment rights as applied to him. The district court agreed with him, but the Seventh Circuit reversed.
Now, hold on. Let's go back to the beginning of the case. Antrim asked for an injunction, and in affirming this court's denial of injunctive release in the case, the Seventh Circuit reaffirmed Ballou? What did you call it?
I think it might be Ballou.
Okay, Ballou, and applied its reasoning to Antrim's claim. In doing so, the Court of Appeals rejected several attempts to distinguish the claim in this case from the plaintiff's claim in Ballou. With respect to the state's interest in GPS monitoring scheme, the court reiterated that Wisconsin has a strong public safety interest in monitoring repeat PFRs for deterrence purposes. Now, what about all that research that they presented?
Well, the Court of Appeals declined the invitation to use social science research to weigh in on the efficacy of the program, noting that the court's, quote, role is not to second-guess the legislative policy judgment by parsing the latest academic studies on PFR offender recidivism. That's what I've also pontificated for a number of years. That is not a compelling argument about recidivism. Now, here's where you can play the little clip that I gave you earlier.
Really? You want me to play this one? Okay.
Yep.
Until you get that through your thick fucking head, you'll keep losing.
Recidivism doesn't win cases, folks. Let go of it.
And then in the conclusion, it states that accordingly, Antrim has not marshaled evidence sufficient to survive summary judgment. In sum, even viewing the record in the light most favorable to Antrim, the court concludes that he has not presented sufficient evidence to distinguish his claim from Ballou and show that there is a genuine issue for trial.
And it's even more difficult to do that when you don't file a response in opposition to their motion for summary judgment. When you also file a motion for summary judgment, you've got duality. Both parties are saying there's no genuine issue for trial. So therefore, there was no trial. Therefore, there's no evidentiary record. Therefore, this case is not likely to succeed when it goes up to the Seventh Circuit because there's nothing for the Seventh Circuit to look at that would compel them because they don't take evidence at the circuit court. The evidence is already in the record.
Now, can you say that a different way for the dumb people in the audience like me?
Well, this record will go up from the trial court. And the evidence that's being shipped up from the trial court is all the evidence there will be. The Court of Appeals will not hear any evidence or entertain any new evidence, admit any new evidence. the lawyers will be arguing, if they even have oral argument, about the evidence, but they won't be introducing new evidence. They will be arguing about what their interpretation of the evidence is. The evidence is already locked in the file, in the vault, and it will not change. I mean, Chance, am I missing something there?
No. I mean, there's some bright and shiny objects here. I mean, one, you've got precedent. Two, you've got what looks like a compelling state interest. I mean, the court emphasized Wisconsin's strong public safety interest in monitoring repeat sex offenders to deter recidivism. And then you've got this balance between privacy and public safety. The court balanced the modest intrusion, it said it was, on privacy caused by the GPS monitoring against the significant public interest in preventing sex crimes, concluding that monitoring was reasonable. So those are bright and shiny objects.
So I know you're not a betting person, but do you see this as a strong case for appellate review at the Seventh Circuit?
No.
It was hard for me to come up with that conclusion that it's a strong case for appellate review.
Are you a first-time listener of Registry Matters? Well, then make us a part of your daily routine and subscribe today. Just search for Registry Matters through your favorite podcast app. Hit the subscribe button and you're off to the races. You can now enjoy hours of sarcasm and snark from Andy and Larry on a weekly basis. Oh, and there's some excellent information thrown in there too. Subscribing also encourages others of you people to get on the bandwagon and become regular Registry Matters listeners. So what are you waiting for? Subscribe to Registry Matters right now. Help us keep fighting and continue to say FYP.
Well, then moving along. You put this case somewhat on point, and it's a PFR brought a lawsuit after he pled guilty to violating a soliciting ordinance. This is James French versus Alicia Lizer, it's got to be Lizer, and that's et al. Now, what was Mr. French's claim?
French asserted that the First Amendment right to free speech has been violated by the Village Board of Dakota, Illinois, when they issued a citation to him for going from place to place distributing door hangers without a permit. He believed that was unconstitutional, according to the Supreme Court's decision in Watchtower Bible and Tract Society of New York, Incorporated versus the Village of Stratton.
Interesting. Now, I understand that Mr. French reached out to Narsal for assistance?
He did about a year ago, but he was not requesting money or legal assistance. He just gave us the information. He stated to us that we have discovered more evidence that the village was trying to deprive me of my God-given rights to free speech. Now, I'm going well script here, but I'm trying to understand something about God-given rights. If God gave these rights to people, how come the whole human condition around the world doesn't have these rights? If they came from God, wouldn't everybody have them?
I think that's a reasonable assertion.
Okay, well then, if everybody doesn't have them, it's clear they were not given by God, because I would think God would have the power to enforce them, right?
Maybe he does.
But anyway, he said that they held secret meetings in the summer of 2023, adopted a new ordinance which says that no permit can be issued to a person, quote, while they are subject to public reporting requirements under the laws of any state. Now, you've got to give them credit. That is pretty creative, because he wasn't under supervision other than registration. So they roped him in that way. And he says, I'm required to register a life. According to this ordinance adopted by voice vote on the 21st of August, 2023, I can never again go from place to place in the village of Dakota. Now, it doesn't say that. It says you can't go from place to place handing out flyers, soliciting. Then he's done a little stretch there, but go ahead.
Now, I'll read directly a little bit from the decision. All parties live in the village of Dakota, a small town in Stevenson County with very few secrets. Because Dakota has only about 500 citizens, residents are generally aware that French was convicted of abusing a young family member. When he began to approach his neighbors' homes as part of a local prohibition campaign, residents contacted the town mayor and the local police department. And at least 2 residents reported their discomfort with a PFR approaching homes with children present. Now, what does the ordinance prohibit?
Well, at the time of the incident, the Dakota's solicitation ordinance read, "It shall be unlawful for any peddler, solicitor, canvasser, or temporary vendor to engage in their respective activities within the village without first making application for a permit therefore. Such application shall be made on forms provided by for that purpose by the village clerk. No permit shall be issued to any person having been previously convicted of any felony." Now notice how they amended it to rope him in. "Falsification of any information contained in the application shall be a prima facie reason for denial of the permit or license applied for." And then it cites the section of the ordinance. "Any person violating the provision of this chapter shall, upon conviction, be fined in an amount not less than $5 and not more than $200.
Well, that's not super serious. I mean, I can probably find $5 and change around the house somewhere.
Well, being a PFR, they'd probably hit you with 200. But
okay.
But no, municipal ordinances generally do not have severe penalties. Chance, can you think of any municipal ordinance that carries an extreme penalty? Because none come to mind. You're going to be looking at
not really. Not really.
3 to 6 months in jail, no more than that, and usually a fine.
Usually, I mean, misdemeanor at max, usually an infraction, a fine, something like that.
So.
Now, was there a problem with the timing of the lawsuit? And what I mean by that, the decision notes that the ordinance conviction became final 2 years ago when a local judge signed and accepted French's guilty plea. Now, for the first time, French alleges that Mayor Leiser, Officer Curtis, and several members of Dakota's Board of Trustees violated his rights under the First Amendment.
Possibly that it was a timing issue, but I think there was more about the merits of the case. He sought compensatory and punitive damages from all defendants. Now, when you start going after punitive damages, that is a really, really high bar, because we don't hand out punitive damages very easily. But in response, the defendants moved for summary judgment.
Here we are again.
It's proper for them. The defendants argued that they're entitled to qualified immunity, and French insists that enforcement of the ordinance violates clearly established law, which is what you have to prove in a 1983 claim.
Now, the town argued that the case was barred on Heck versus Humphrey. Now, what did the court determine on that?
Well, after reviewing the parties' briefs, the court raised the issue of favorable termination under Heck versus Humphrey. And I had to read that case about 15 years ago because the government used it arguing against my action as well. And I vaguely recall that it has to do with if you're trying to backdoor litigate your previous conviction, it's a bar to that. That's what I vaguely remember. But the court briefly explained its concerns in a minute order and allowed French to file supplemental briefing explaining why his claims aren't Heck barred. And French timely filed that responsive pleading.
And what was the ultimate ruling? Are his claims barred by Heck versus Humphrey?
Well, the court noted that French tried to distinguish his case from the facts of Heck by noting that Heck raised a constitutional challenge to investigators' pre-trial conduct as opposed to challenging the constitutionality of the underlying statute. This distinction, as best the court can tell, is French's own invention. So it doesn't sound like they liked it very much. He cited no authorities reflecting this novel restriction, and the court's independent research revealed several cases applying the Heck bar to First Amendment challenges. The court stated, quote, "Together, Heck and its pogency." Now, what does pogency mean, Chance?
That's progeny.
Progeny. All right.
Is it progeny?
Progeny.
Yes. There we go.
Progeny. What does progeny mean?
Isn't that like
progeny?
Your
well,
family
other cases
members?
similar to it.
Okay.
Heck and its progeny compel summary judgment for the defendants. But there was another problem with French's claims.
And what's that other problem then?
To survive the clearly established prong of qualified immunity analysis, a plaintiff must demonstrate that existing precedent at the time of the incident placed the constitutional question beyond debate. And they cited Ashcraft versus Al-Kid. I'm not even familiar with that case. though French correctly notes that the door-to-door solicitation receives some First Amendment protection, he doesn't offer any current case that identifies the scope of those protections for PFRs. In addition to the judge who accepted French's guilty plea to the ordinance violation, other courts have affirmed the constitutionality of enforcing restrictions on door-to-door solicitation against registered PFRs.
Do you think this case is dead?
It's definitely dead. If he were to try to take this case any further, I'm not admitted to the bar, but I think that he would be running the risk of, what is it called, Chance, when you do litigation that lacks no merit whatsoever?
Frivolous litigation.
Yes, I think he's in danger of being sanctioned for frivolous litigation.
Well, all right then. Let's move over to California Corner, your go-to part of the podcast for all things legal in the Golden State. Now, Chance, what are we going to be talking about tonight?
Well, thanks, Andy. It's great to be back. We've got a fascinating case on the docket today, which I've probably mentioned before, but I want to get into a little bit deeper because it is a very, very good case, which pretty much defines what certificate of rehabilitations are and what you need to do to accomplish that in the state of California.
And this is People versus Rounds, where the California Court of Appeal reversed a trial court's denial of George Dennis Rounds Jr.'s petition for a certificate of rehabilitation and pardon. Would you set the stage? What led to this case?
Of course. The case centers around George Dennis Rounds Jr., who in 1983 was convicted of second-degree murder and attempted murder. He served his sentence, was paroled in 2010, and discharged from parole in 2014. In 2021, he filed a petition for a certificate of rehabilitation and pardon, presenting his post-release rehabilitative efforts. However, the government, represented by the district attorney, opposed his petition.
And I guess that's probably no surprise, but what is surprising is just how strong the opposition was. What were the key arguments from the DA?
Well, the district attorney contended that Rounds had not demonstrated three critical components: insight, accountability, also known as responsibility, and restoration, which would be his efforts to rehabilitate. First, they argued that he lacked sufficient insight into the nature of his crimes and the harm caused. Second, they claimed he failed to fully take responsibility, pointing to perceived inconsistencies in his explanations of the events. And lastly, they asserted that he had not shown enough evidence of being restored to a state of moral character and fitness to regain rights that he lost due to his conviction.
Wow, those are pretty tough arguments.
Yes, they are, in fact. And this is where petitioners typically lose, because California trial courts have very wide latitude in these hearings and can only be challenged for an abuse of discretion, which is almost impossible to establish on appeal, as Larry will tell you. So
now, how did Rounds counter this?
Okay, that's where the rubber meets the road. Rounds presented a compelling case for his rehabilitation. He demonstrated his commitment to community service through programs like Operation New Hope, earned educational achievements, including an Associate of Arts degree and certification as a diagnostic radiologic technologist. Don't even ask me what that is. And maintained stable employment with Amazon for 7 years. I don't know anybody who can do that, but he did it.
I know, right?
He also founded Driven Bound LLC, which is a business focused on mentoring male youth and teaching life skills. He provided support letters from community leaders, colleagues, and family members, all attesting to his positive transformation and moral character.
And then, despite all this, the trial court said that the district attorney, they sided with the district attorney and denied his petition. Why did they do that?
Again, wide latitude. The trial court's denial was based in part on considerations outside the statutory criteria for rehabilitation. Specifically, they weighed the severity of Rounds' original crimes and concerns about fairness to the victims, factors that the appellate court later found to not be relevant.
If you don't mind, Andy, I'm interested in the appellate court's response. How did they address the trial court's decision?
And this is interesting because the appellate court found that the trial court actually did abuse its discretion by focusing on inappropriate factors. And I want to tell you, this happens all over the state, but thank God this thing went up to the appellate court, and that's what they found. They emphasized that the law requires courts to assess rehabilitation based on statutory criteria, stuff contained in the law, such as good conduct and moral character, that is demonstrated, guess what? Post-release. The appellate court ruled that Rounds had met these criteria through his consistent efforts and contributions to society. As a result, they reversed the trial court's decision and went far enough to direct them to grant his petition.
And now that's a powerful conclusion. What does this case teach us about the legal system then?
Most importantly, it underscores the idea that the legal system should focus on rehabilitation and second chances when individuals demonstrate genuine change. The appellate court's decision reinforces the principle that petitions like these must be evaluated based on the law, not on subjective factors like the nature of the original crime or perceptions of fairness to victims or anything else outside the parameters of what the law actually says.
An inspiring message about redemption and the rule of law. Thank you for Chance for unpacking this case.
My pleasure. It's a story that highlights both the challenges and opportunities in California's justice system, and this case is one very bright light.
Well, I can just say you guys have got a bunch of liberal, out of control nut jobs on your court out there is all I can say.
Crazy as hell.
Now, Larry, this story was published yesterday, and it is from the floridabar.org, which I will assume is the Florida's Bar Association for them attorney peoples.
Could be.
And it says the Florida Supreme Court has revised the state's criminal procedure rules, amending the speedy trial procedures and timeline for filing formal charges. The new rules, which take effect July 1st, extend the recapture period, set a new starting point for speedy trial deadlines, beginning when formal charges are filed rather than at the time of the arrest, and set a 60-day deadline for the state to formally charge a defendant on pretrial release. The 6-1 court acted March 13th in regard to amendments to Florida Rule of Criminal Procedure 3.191, case number SC 2022-1123, with Justice George Labarga dissenting. Did I do that right? George Labarga?
Looks like.
You did very close.
It's a chance. What do you think is wrong with this?
This is just rigging it a little bit so that the prosecutors get their stuff together. The story appears to say that speedy trial periods now begin from the date formal charges are filed rather than the date of arrest, the period within which the court must set a cause for trial to begin in no less than 5 days. But the 45-day period has been extended to no more than 60 days from the date a speedy trial demand is filed.
And then it states that dismissals under this rule will be without prejudice unless the defendant's constitutional right to a speedy trial is violated, in which the dismissal will be with prejudice. Now, did I have that right?
It says the court also amended Rule 3.134, time for filing formal charges, to require the state to file formal charges against defendants on pretrial release within 60 days. If charges are not filed by the deadline, the defendant must be released on their own recognizance unless good cause is shown. Okay, so I think that's okay. But I mean, your question is that correct? Yeah, that looks like it's correct, because if your speedy trial right is violated, it is dismissed with prejudice, and that's the end of the case. What they've done is they've rigged it so that if they're slow to go, they get a second chance. Second bite of the apple.
Now, Chance, they wouldn't do that in a good constitutional state like Florida, where they believe in the rule of law. They would not rig anything against the accused.
Oh, they get second, third, fourth, fifth, sixth, and seventh bites at the apple under this thing.
Not in a good not in a law and order, but in a good constitutional state like Florida, they wouldn't do that. You've got to be misunderstanding this.
No, it must be. I must be dreaming.
But I think you might be on the lines with the dissent. In dissent, Judge Labarga said, the amendments adopted by the majority, which further relaxed the speedy trial rule, are unwarranted He said, first, I strongly disagree with the majority's decision to define speedy trial for the purposes of this rule as starting from the date that formal charges are filed rather than the date of arrest, which is the date I prefer. He noted 5 years ago in Davis versus State, the court adopted the formal arrest standard as the starting point for running of the speedy trial clock. There, I dissented to the majority's position that speedy trial is in no way implicated by the length of the investigation or the fact that the individual under investigation is a known suspect. To the contrary, Labarga observed a formal arrest standard would allow law enforcement repeatedly detain an individual for an extended period of time without triggering any procedural expectations. Can you expand on that as a practitioner of what we're talking about doing here in the state of Florida so that our massive audience will understand what this is going to be like after July 1st?
Well, they just can keep on digging until they find something. They can hold you in check until they do without violating any of your constitutional rights, looks like.
That's what it looks like to me. It looks like if they can arrest you and you can't post bond, it looks to me like that they basically can just warehouse you forever. And I hope I'm misreading this, and the Floridians can feel free to correct us, but that's what it looks like to me.
And the Florida Association of Criminal Defense Lawyers President Jason B. Blank said the Florida Department of Criminal Lawyers is extremely disappointed the court disregarded the real-world concerns we voiced about how this amendment will affect the criminal justice system and its participants. The negative impacts will be felt in the courts across the state and will hinder, not help, justice being found by defendants and victims alike.
Nonsense, Andy. That's coming from a crybaby liberal, Jason Blank. You ought to be ashamed of yourself.
I'm just reading what he said. I'm not saying I said that. I'm not saying that's your opinion. That's what he said. And are there any pointy-headed liberals anywhere in Florida?
It sounds like Jason Blank is thinking that there's somebody that's accused of a crime ought to have due process rights and any presumptions. That's crazy talk.
Notice that it comes from the Florida Association of Criminal Defense Lawyers. Their very president, Mr. Blank.
I noticed that. Well, very good. What else do y'all want to talk about for the next 3 minutes?
We need to talk about our vast audience. It's growing by leaps and bounds. What can we do to better serve them?
We did get a new patron, and I would like to say a very welcome to Jake, who was joined at a very generous level. Did you talk to him yet?
It is on my list of things to do. I was hoping he would be here tonight, but I will be contacting him very soon. Maybe as early as tonight or tomorrow.
All right. I do have a merch on display back there. I have the Kabuki machine, Larry. It's your favorite thing. It's a whole shirt with the Kabuki machine on it. Head over to fypeducation.org/shop, and you can find all of our amazing merchandise there.
No one has reached out to me telling me that they've taken that into their examination yet. that they've worn that shirt for their polygraph examination.
Remind me, is that the did you say $1,000? That's what I'm remembering.
I don't think it was quite that generous. I think I said I was going to buy the shirt for anybody who wanted to wear it for their exam, for their PFR exam.
I thought you were going to make an offer like James Randi did of anybody that could actually show evidence of supernaturalists, that he would offer them $1 million. No one ever was able to show him in a controlled environment. So I thought you were doing the same thing. If you wear this into the thing and you could get a selfie with like the polygraph examiner, that you'll send them $1,000.
I don't think I can afford that.
Caden says he would wear it, and Carl also said that he would too.
Well, I'm looking forward to having that confirmation that they've done that.
Let's see that selfie. Let's see that selfie.
God, that would be so funny. That would really be fabulous to go in there wearing, and you're like holding it up by the thing and like holding it up so that everyone like, I'm wearing this, MF. I'm wearing this. Oh, I hate the Kabuki machine so bad. Oh, I hate that thing so bad. Anything else, gentlemen, before we close out?
Just thank you for all that are listening to this and benefiting from it. Thank you so much.
I started releasing stuff back on Reddit because there's 12,000 people over there on the SOS support forum over there, and so anybody over there, welcome, hello. There will be posts over there in the next week or so when this goes out. So head over to registrymatters.co, and you can find show notes. and email registrymatterscast@gmail.com. And I didn't mention it at the beginning of the show, but please, if you can support us at patreon.com/registrymatters, it is incredibly appreciated. But if you could even as much as leave a 5-star review, rating, share it with everybody that you go to treatment class with, tell them about the podcast. We would certainly love to grow our numbers and have more people. You can find it everywhere just by searching for Registry Matters. And without anything else, I hope, gentlemen, you have a great weekend, and I will talk to you both very soon.
Thank you. Thank you.
Good night.
You've been listening to FYP. You've been listening to FYP.